It is August 4th of 2026, and this is the Court Gallery. Today's cases feature defendants and plaintiffs struggling to grasp reality. We kick things off with Judge Aquilina handling a plaintiff who refuses to accept the settlement over his ex-fiancee's bad car loan, trying her patience with demands for emotional damages. Then, Judge McNally completely loses it on a defendant who is currently on his fifth court-appointed attorney. And a routine wellness check spirals into chaos when a suspect fights multiple officers, leading to an officer with a broken wrist. Finally, Judge Webster handles the traffic stop that yields drugs, and the driver tries to blame another police department for planning it. Buckle up. It all starts right now.
This is docket 25-6558 CK, Richard Robinson versus University of Michigan Credit Union. Counsel, your appearance for the record, and sir, you are Mr. Robinson?
Yes, I am. I'm Richard.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide be the truth, whole truth, and nothing but the truth and the perjury?
Yes.
Thank you. Put your hand down. Counsel, your appearance.
Good morning, Your Honor. Scott Shredder, on behalf of the University of Michigan Credit Union.
Thank you very much. And sir, we have a couple of, you found a couple of motions.
Yes.
Have you reviewed those, sir?
Well, just as a matter of housekeeping, there were a number of motions that Mr. Robinson filed. We were put in advance or held in advance so he could get counsel. I think what's before the court today is Mr. Robinson's request to this court to extend the date for him to obtain counsel and to
have a stay.
Yeah. Because of before the court.
But didn't I order? Did I order a judgment in this or no?
No, there was no judgment.
Okay. There's just some back and forth here, but Mr. Baldori was out. All right. Okay. Thank you. Sir, at the podium, please. What would you like me to know in regard to your motion, and tell me what you've done to find counsel?
What I have done.
Sir, at the podium, please. Well, I guess you can stand there as long as you keep your voice loud. That microphone's not great. Thank you. Okay.
I've worked, hello, Your Honor. I've worked earnestly trying to find an attorney. I've called at least 15 to 20 attorneys to try to work with me on this case. The issue is that I'm having is that they're reluctant to work with me on this case because documents have been filed and attorney and my former attorney has been dismissed. And so that is their reluctance. I have called the state bar. I'm working with them to try to find counsel to represent me in this area. And that is the reason why I have come to the court before the expiration of those 45 days that the court gave me to find an attorney. I'm here before the court before the expiration of that, seeking another 45 days. In addition to that, defendant has requested information from me, and that is the reason why I am asking for a stay in proceedings so I can get legal counsel. And I would also like to request within that 45 days to be able to file another brief within that 45 days, because I need that to be able to adequately defend myself. I'm up against a wall here, and I'm working on this every day to try to make this happen within the time frame that the court has given me.
Response.
Thank you, Your Honor.
Sir, if you have a seat and then counsel will up here, that's okay.
Thank you, Your Honor. It's trying to put it into some perspective if we can.
And could you just remind me when you're doing that? I thought there was an agreement already in this.
I was going to get to that.
And the agreement was through mediation, through counsel, that you pay, I think, $4,000, right?
The credit union would pay $4,000. That's correct. Yeah. To back up just a bit, prior counsel is involved. We've got what I believe to be a settlement here. When we attempted to finalize that by exchange of money and documents, some turmoil between the plaintiff and his counsel. Counsel then withdrew after Mr. Robinson had indicated that he didn't agree to the scheduling conference order, which is now implicated by the motion because we've put on 45 days. I've sent some discovery to Mr. Robinson. He doesn't want to provide it. So it stands now from the credit union's perspective. We have a settlement. Now we're backing up to allow Mr. Robinson to obtain another lawyer and give him more time after he's the one that filed the complaint.
And sir, could you remind me, the scheduling order, I remember hearing arguments from counsel. Was this was in mediation? Was it signed by the mediator and or all parties?
It wasn't in mediation. It hasn't gotten that far.
So what was it in?
It was an exchange of emails between myself and counsel.
Okay, that's what it was. I got a couple of these actually. People agree and then they apply with remorse. So, okay, I remember, I think counsel, it's probably somewhere in my files still, exchanged the email.
Correct.
Okay.
In which Mr. Robinson's counsel said, we have a deal for the $4,000 in releases.
So explain to me how a case of $4,000 ends up in front of me.
Well, that's a very good question, especially in light of the fact that the underlying case was in front of Judge JMO to start. Why that wasn't indicated by Mr. Robinson or why it wasn't assigned a vehicle to let him essentially out of the deal.
Do you recall how much the lien was on the vehicle?
My recollection is that the borrower, Ms. Egger, owed somewhere in the area of $1,800.
Okay.
And that the vehicle securing the debt was you have to forgive me, it was a Honda, is that correct?
The vehicle securing the debt was a Volkswagen.
What year was it, sir?
It was Volkswagen Jetta 2010.
2010 Volkswagen Jetta. So one circumstance or another, University of Michigan tried to release the lien. They sent the lien release to Ms. Egger instead of Mr. Robinson. Mr. Robinson then 3 years later brings this lawsuit to say that somehow we defrauded him into this settlement to release the lien on his vehicle. Since then, the credit union has provided Mr. Robinson with the lien released. So he's out of the underlying debt to the University of Michigan Credit Union, and now he wants damages. The damages we calculate to be at most what he had to pay out in attorney's fees to bring the case, because now he's got relief. In other words, the vehicle's free and clear.
And he has a vehicle?
He does. We never repossessed it.
Do you know did you ever figure out the blue book on the Jetta? My dad loved Jettas, by the way.
Yeah.
It's a very good car.
Apparently it's still running and after all these years, and I just have to smile because it just, my father's deceased now a couple of years, but we had a few Jettas in the family. I always drive American, but I have a few family members who like the Jettas, so I'm just smiling because it is a good car. Apparently.
It's a very sure.
Yeah. So do you know what the blue book is?
The blue book is, as I understand it, is somewhere around $6,000.
Okay, thank you. May I have a seat?
Sure.
Could you please?
Thank you.
May I speak, Your Honor?
Yes, that's what I'm asking you to do. We take turns, so. See, I can tell you're not a criminal because you don't know your way around the courtroom, so that's a good thing. All right. So that's okay. So, sir, I have some questions for you. Why do you think the $4,000 settlement was not good enough? Were your expenses covered? You have the vehicle.
No, but my expenses weren't covered. If I can go back just a little bit, Your Honor. When that agreement was signed some 3 years ago, I signed the agreement. The opposing defendant signed the agreement. But the credit union never signed the agreement.
Well, they have emails. I saw emails last time that everybody, all the attorneys agreed.
No, this is the underlying case.
Oh, the underlying case.
I
Okay.
went to Mr. Chernich
Okay.
personally on 3 occasions within that 3-year period of time. And I asked him to sign the agreement. And I found documentation with the court to show that.
Okay.
Over that 3-year period of time, Mr. Chernich did not sign the agreement.
Okay.
That is the reason why I brought the suit, because my car was still being held in possession of the credit union. They still had a lien on the car.
Okay.
And to answer your question in regards to the $4,000, I believe that the damages that I've suffered, both mentally damages and other damages, far exceeds the $4,000.
Tell me about that. Let me just say, sir, are you afraid to drive? Are you afraid of attorneys? Are you housebound now? Are you losing sleep, in counseling, taking meds? I mean, what has this caused?
I have been taking medication. I am seeing a psychiatrist. I have been going
All related to this?
Related to this issue. And this issue has been going on for 3 years. And this is an issue that I have tried to resolve 3 years ago by going to Mr. Chernich on 3 occasions. And on each occasion, he refused to sign the agreement. So what I am asking for now is the 45-day extension, a stay of proceedings, and the right to file an additional brief within that 45 days to explain my position. And I don't want to take up a lot of it. No, I'm sorry, I didn't mean to move that. I didn't want to take up a lot of the court's time. And within that 45 days, something has to happen, because I'm not going to come back and ask for additional time. Within that 45 days, it's either I find counsel, I drop the case, or I move forward in pro court.
Well,
But within that 45 days.
sir, I need to understand something. You have the $6,000 Blue Book jet. You like the car. It's yours free and clear. Prior to this case, there was an $1,800 lien, which has been forgiven. So now you have a car without a lien, free and clear ownership, correct?
Yes,
Okay, so you're under that you were not the borrower, or you were the borrower?
I was not the borrower.
Okay, so how did you get this vehicle?
Oh, I owned the vehicle.
So how did it have an $1,800 encumbrance on it?
What happened was, this was my former fiance.
Okay.
And she used the car as collateral for the loan.
And she had no right to do that.
And she had no right to do
Got
it.
it. Okay, so now that has been wiped away. So now you have a free and clear car.
Yes.
And on top of it, in order to cover your attorney fees, they've offered $4,000, which your attorney at that time agreed to.
But I instructed my attorney, I gave my attorney direct instructions in an email to not accept any offer without my written consent.
Well, that is your right, and that might be malpractice, but the problem is the other side relied on it.
The other side relied on it, but there's something else in addition to that, Your Honor, is that on the other side, in the release says there's a mutual release. My attorney accepted it, and it said there's a mutual release of claims. My attorney, my former attorney, has come back to me and said, because I asked him, what does a mutual release of claims mean? A mutual release of claims mean that all of the claims in the former lawsuit that defendant had against me would be dropped, and all of the claims in the current lawsuit that defendant has against me would be dropped. Neither one of those terms are in this settlement, this purported settlement agreement.
Okay. Is that what you want? Do you want that?
No, I don't want that settlement agreement. I believe that settlement agreement is unenforceable, and I can prove that that settlement agreement is unenforceable.
How?
I can prove that based upon my attorney saying what should have been in that respective, that settlement agreement. I have it in an email, and
So
those terms are not in the purported settlement.
I got that, but sir, I think maybe I asked you a bad question. Let me rephrase my question.
Yes,
Let me
ma'am.
take some responsibility for that. What I'm asking you is, would this agreement be acceptable to you if it contained the mutual release of claims?
No, it would not,
And why is that?
because I believe that the $4,000 that was settled against, the $4,000 that was entered into the settlement is not adequate to compensate me for my damages.
How much did you pay in attorney fees?
In attorney fees, I paid somewhere around, I believe it was about $1,700. But I've been going, as I said earlier, I have documentation of my psychiatrist that I have been seeing, the medication that I have been seeing, the medication that I have been taking, all because of this particular incident. And I've been going through this for 3 years.
Okay, well, let me ask you a couple things. So basically, there's a $2,300 over the amount of your attorney fees. Okay, so in regard to the $2,300, you're saying that's not enough to cover the damages, correct?
Yes, ma'am.
Okay, then are you saying that the damages are caused by the University of Michigan Credit Union, your attorney, or someone else? What
My
does that say?
damages are caused by the University of Michigan Credit Union.
How?
My damages are caused by the University of Michigan Credit Union because for a period of 3 years, they did not take the lien off my car. And when I went to them to take the lien off my car on 3 occasions, when I went to Mr. Chernich and asked him to sign the agreement, he refused to do it.
Sign which agreement?
To sign the settlement agreement in the underlying case. Mr. Chernich refused to do that, and I submitted documentation to the court showing that he refused to do that on 3 occasions. This is the reason why I brought this case,
Okay,
and this is the case.
so let me just stop you there. I want to understand some of the working pieces here.
Yes,
Your former fiance.
yes.
Sounds like it's good that she's a former fiance.
Oh, she's a very nice person.
I'm sure she is, but we all have formers and we're
Yes.
glad of it.
I never
Good
say
people.
anything bad about her.
Okay,
She's a nice person.
Okay, but this nice person might need to be brought in this case because it appears that the starting point of this was your former fiance getting $1,800 against a vehicle she had no right to.
Yes.
So why is she not in this case, and why are you not claiming damages against her?
The reason why she is not in this, she was originally brought in this case. I instructed my former attorney not to dismiss her, and he dismissed her from the case.
Okay. I mean, if this is reopened, she's going to be brought back in, whether it's
Yes.
under me or the University of Michigan, because it sounds to me like she caused this. She was the pebble that turned into a rolling stone.
Well, she started it, but then the University of Michigan refused to sign the agreement. And when they refused to sign the underlying agreement, and again, I went to them on 3 occasions. I went to Mr. Chernich on 3 occasions, asking him to sign the agreement, and he refused each time. This is the reason why I'm bringing the suit. This is the reason why I have these psychological and mental damages, which I have documentation of.
Mr. Chernich is not in this case, so you might have a claim against him in terms of, and I hate to always say this against
But I asked him,
not, sir. He
I'm
might
sorry.
have, and trying to explain to you, because this case is very fragmented. I'm not sure all of your claims fall under here. So you can certainly make a claim against him with the State Bar of Michigan if you believe he did not represent you properly, you could also file a malpractice suit against him. But that your relationship with your attorney, or the attorney for, I guess, University of Michigan, as he was representing the University of Michigan.
Mr. Journeys was representing the University of Michigan.
Okay, I'm sorry. So, but what about your attorney? You said your attorney.
Yeah, my attorney that I asked to withdraw, he was representing me, and it is the University of Michigan that caused me to have these damages.
Because they didn't agree with what you did. So, because I was getting my parties.
Because they did not
I just wanna
sign
make
the
the record.
agreement.
So there's no claim that you would have against Mr. Attorney.
No.
Because they didn't represent you. I forgot there was the other attorney release, but.
Yes, no claim against Mr.
Right.
Church.
So he's representing his client. They don't have to agree to what you want. But there is this agreement. So your claim may be against your attorney who entered into this on behalf of your, against your wishes.
But that agreement is not a valid agreement. Even though it was done via email, that agreement did not have the terms in it that were supposed to be in it.
Okay, but I can fix that. I can put the mutual release of claims. Are you in agreement with that?
I'll do it right now, yes.
Okay, and
But-
what other terms are not in there?
But that's not what I want, Your Honor. That
We
agreement
don't-
not only did not have the terms.
I'm not in the happiness business. I have to follow the law. And if there's an agreement, I'm going to make it better for you. I don't know if you can prove damages more than $2,300.
But I can prove that, Your Honor, and I need 45 days to be able to do that. That's all I'm asking the court to do, and I can do it within that time frame. That's all I'm asking the court to do is to give me 45 additional days so I can prove that to the court.
So you want this to come out because there's different laws in Michigan, and it can go by percentages. And so if the credit union is willing to give you $2,300, you might have to get the rest of the money from your former fiance
But the
and
amount,
maybe your former attorney.
but the amount that the credit unions offer, that's an amount that I did not agree to. And I can prove that agreement was not valid. And that's why I'm asking the court to please give me 45 days
So you
so I
understand
can
that,
prove
sir.
that.
But then your former attorney may need to be brought in and your girlfriend.
And that will be fine, sir. And I will do that.
But then I can release the University of Michigan. Your claim now then would become against those two.
But the University of Michigan, based on this agreement, it is not valid. That agreement is not enforceable.
It is enforceable based on the emails that I saw. There was agreement. Your attorney agreed. Maybe should have talked to you. That's malpractice. That's a different problem. And you may have a claim against his insurance company and your fiance. It's just a moment. Sir, from there, you can answer this question.
Yes, ma'am.
What, in regard to the, I don't know, I'm going to phrase this horribly, so you fix it for me, okay?
Sure.
The credit union's responsibility because it's not just a responsibility to this stakeholder, but to all stakeholders who are in the credit union.
Correct.
And you have a lot of rules that you have to follow. And some of the rules that you all follow drive me insane as a consumer. Okay,
Understandable.
so
I draft those.
yes. So were you on the underlying case, were you able to do what Mr. Robinson wanted, or were there federal rules against it? Does that make sense to you?
I think so. Let me answer it this way, if I can. The crux of the settlement and the underlying lawsuit was for the credit union to release the lien. As I indicated to the court earlier, the credit union did that and sent the release of lien to Ms. Egger, which is Mr. Robinson's former acquaintance.
And I understand that,
And
but
then-
I want to take you one step backward. If
Sure.
you remember,
Yep.
he's claiming that this occurred over 3 years should have been done immediately. Did the bank delay, or was it his former fiance that delayed? I mean, what caused this?
It was a mistake. The release of lien went to Miss Egger instead of him. And then 3 years later, he brings this up. Now we sent him the release of lien. He's got it.
Okay. So why was it sent? I get to you, sir.
Yes, ma'am.
Why was it sent? I understand the mistake.
Yep.
Banks don't generally make that. But was it sent to her because she was the one who took this out with his, was it with his permission or without?
He alleges it was without.
Well, would the bank do that without? If we went into the bank records, I mean, I find it hard to believe that the bank, any bank, especially a credit union, with the extra layers of protection credit unions have over and above extra banks. I mean, they just have extra rules. I find it hard to believe that the University of Michigan Credit Union gave a third party a lien on his vehicle or any others without his permission, approval, whatever. How did that work?
We have
Do
a
you know?
very long history of his consent in allowing the lien.
And is that in writing?
Yes,
So he consented to her having this.
correct.
Sir, explain that one to me.
Okay,
How did they cause a problem if you consented?
okay. My ex, which was as part of the underlying case, asked me to sign a document. I signed the document. It was my fault. I didn't know what the document was. We made an agreement in the underlying, myself, the credit union, and my ex.
Okay.
We all came together. I signed it on December the 23rd, 2022.
Okay.
My ex signed it on December the 23rd, 2022. The agreement was sent to the credit union. The credit union did not sign the agreement. I went to the credit union on 3 occasions to ask the credit union to sign it. They would not sign it.
Was that the agreement to have? What was the agreement?
The agreement was for once the agreement was signed, for the immediate release of the lien of my car.
Which they eventually did.
3 years later.
Okay.
And so again, I asked the court in regards to this purported settlement. I can prove that this settlement is not enforceable. If the court can't give me 45 days, then please give me 30 days. And I can prove that this agreement is unenforceable. And if you would allow me to have a stay in proceedings and also to submit a brief, I can do that within 30 days.
You can't have both a stay and submission of brief. The brief would have to come after the 30 days. But nonetheless,
After the 30 days.
sounds like this is a breach of contract case. Isn't the statute of limitations on contracts 2 years? Why are we here on that?
Statute of limitations, 6 years.
Oh, okay. I don't think that's this. Okay. So
And I don't want to
why would I don't, sir, I don't know how you're this case should not be before this court. First of all. Second, it's going to cost more to try this case than you're going to get. And I'll tell you why. I want you to think about this. You're going to have to get a psychiatrist, psychologist, doctors, all of those are expert witnesses to talk about how this impacted you so much that you have to be medicated, go to counseling, et cetera, et cetera. Then, on top of this, the liability will have to be divided between your lawyer, your ex-girlfriend or fiance, and the University of Michigan. And if it goes to jury trial, I don't have a crystal ball, but I've seen these kind of cases. Ingham County is very cheap on this. And they're going to look at a healthy guy who can represent himself as you have, and be very organized and say, we're not doing anything. Or they'll enforce the 4,000 and you're going to be out thousands of dollars on the expert fees. Plus, if we go to trial, there's a court rule that says if you lose, and you may very well, you have to pay the defendant. So are you willing to take all of that as a risk? Because there's a lot going on here that I don't see needs to happen in a court of law, at least this court.
I am willing to take that risk.
That would stress me out more than what you've already gone through. You understand this is going to elongate everything and cost you a lot more money.
I am willing to take that risk, Your Honor. I asked the court for 45 days.
Well, here's how I'm willing to resolve it. And I'll give you both a few minutes to tell me how I shouldn't do this. I am willing to enforce the $4,000 and add the mutual release of claims and whatever else you think should have been in this contract. It sounds to me like the University of Michigan Credit Union is agreeable to whatever the terms should have been that were not specifically in there. And then I'll give you the 45 days to bring in your attorney and your former fiance.
Your Honor, the motion that I appreciate very much of your input. The motion that I made today was to get an extension.
I understand. I'm not going to do that this way because I'll tell you why. I'll tell you why.
Yes, ma'am.
First of all, the credit union has eaten. They're paying you essentially $5,800. The $1,800 was forgiven because right?
Let me just clarify that. Ms. Egger agreed to make payments on the 1,800.
Okay, but it was
She agreed to release the lien for that.
okay, but it was, so you're getting that from her.
Perfect.
Okay, so that's done. I don't know. And the credit union's willing to pay you the $4,000, of which $2,300, it looks to me approximately, goes to your damages. And I'm not sure you can prove the rest. And it's going to, I think that the University of Michigan has done what they can do. And the other two parties need to be brought in.
And yeah, I appreciate your comment. I appreciate what you're saying. You asked me, am I willing to take that risk? I am willing to take that risk. And that is because I believe that I can prove that the $4,000 agreement is unenforceable. So I go back to asking the court.
I'm telling you, it's enforceable. It's enforceable because your attorney signed it. And when he was here, I think there was an allegation and there was an exchange of documents in writing. And while you may not have agreed with your attorney, he agreed on your behalf, which is what the representation is, which is why I go back to it might be malpractice. But there was an agreement brought to writing.
There was an agreement brought to writing, but there is case law that proves that that agreement is incorrect. There's case law that proves that that agreement is unenforceable. And that case law indicates that when a agreement under, I believe it's MCR 2.50.
Okay.
When
it was based on mutual mistake and all these other things, but
no, it was that agreement was put together. In that agreement, it says that we're going to have the defendant offered a mutual release. My attorney offered a mutual release of claims. I have an email from my attorney that says what the mutual release of claims would mean. And I explained that to the court, that the mutual release of claims would be a dismissal of all the prior claims from the defendant and the claims here. That was not in the agreement that was subscribed. Case law indicates from the Michigan Appeals Court. Case law indicates that when you have an agreement and those terms are not in the agreement, and you're supposed to put another agreement together where those terms will be in it, the underlying agreement is unenforceable.
Stop
That is
there.
case law.
Counsel, was that an actual term that was agreed to that should have been put in writing? Do you recall that? I don't recall reading that in the email that went back and forth. I recall the $4,000.
I believe it was offered and accepted, $4,000 in mutual releases.
Okay.
But the
Which I'm happy to give.
Okay, so was this ever reduced to writing and did you give him the 4,000?
No, because he fired his lawyer.
So that was in there, was in.
Correct.
Okay,
the 4,000 is in the agreement, but the terms is not. And based on the Michigan appeals court case, those terms have to be in the agreement.
do you have the email that says that, sir?
Oh, I'm sorry, I didn't bring that with me. I wasn't prepared for.
Do you have it, do you have a phone that you can look it up on, or could you,
Your Honor, if I could look at the file,
It's in the file.
I filed responses to.
is it in your reply, is it in this?
Yes, yes.
Okay, let me see. I remember looking at it last time, I just, there's so many attachments. Oh, wait, here. Exhibit 4?
I believe that's it, Your Honor.
Okay. Okay. And Counsel, I couldn't have you look at this, but I do have a very detailed letter that your attorney sent to you. I'll just read it. It says, Richard, on May 4th, 2026, I sent Scott Turnage an email providing him our counter proposal to settle the matter in exchange for UMCU paying you $12,000 per your instructions, and then I then had a call with, and it was wipe it out, I think, because I don't have what that says. On Friday, May 8th, 2026, you and I had 2 telephone conversations. In the first call, we discussed that defendant was likely only to offer somewhere around $2,500. You told me you were looking to get $5,000 or something close to that. I then sent an email to UMCU's attorney stating that you would likely be willing to consider something around $5,000 to settle the case. He said that he would speak with his client and get back to me. On Monday, May 11th, 2026, Scott Turnage emailed me and said that his client was willing to offer $4,000 to settle the case. I immediately called you that day to convey the offer. I left you a message and you returned my call around 4:30 that afternoon. We had a long discussion about your case, the offer, and the expected costs for you to move forward. You unequivocally told me at the end of that conversation that you would accept the $4,000 offer from UMCU. I then conveyed your acceptance of that offer to Turnage. I then spoke with you later that evening and let you know that the case was settled, and I told you that I had agreed to draft the settlement documents. You instructed me not to send the settlement documents to Turnage until you had an opportunity to review them. I told you that I would email you the draft. We set a call for May 27th, 2026, for you and I to discuss the draft of the settlement agreement. However, you indicated that you had just been released from the hospital and you would need a few more days to recover before addressing the settlement agreement draft. We agreed to touch base early this week. And I just want to note this letter was sent, or this email or letter, whatever it was sent to you Tuesday, June 2nd at 4:55 p.m.
Yeah, please look at the letter.
And let me read. We set a call for May 27th, 2026 for you and I to discuss the draft of the settlement agreement. However, you indicated you'd just been released from the hospital and you would need a few more days to recover. We agreed to touch base early this week. You contacted my office June 1st and set an appointment for a call later this week. This call was just to go over the draft of the settlement agreement together before we sent it to Turnage. In fact, you are now claiming you never agreed to the settlement. The fact that you are now claiming you never agreed to the settlement is concerning. We had more than one conversation about it. You agreed to accept $4,000. I then confirmed the settlement with you that same day, and we discussed the drafting of the closing documents. If you want me to withdraw as your attorney in this case, that's fine, but please know that this does not and will not change the fact that a settlement was reached May 11th, 2026, when you agreed to accept the $4,000 offer. So how does this change?
This changed because on March the 2nd, I sent my attorney a letter, and that letter should be in that packet. On March the 2nd, which is way before his letter sometime sent to me in May, I said to him explicitly, I said, there's a lot of offers going back and forth. Do not accept any offer without my written consent. I also sent him a letter on March the 2nd and told him what the terms of that
Okay.
has to be.
Okay.
Those terms were not in that agreement. The amount I did not agree to, and I can prove that.
You can change your subsequent agreement with your attorney. It sounds like you had a very long agreement with the attorney on June 2nd, and you agreed to the $4,000.
I did not agree to $4,000, Sean. I did not agree to that amount.
All right. What else did you want in the agreement?
In that respective agreement, I wanted more than $4,000.
Or you wanted maybe $5,000?
No, Your Honor, this agreement started off, the offers going back and forth started off at about $18,000. And as you just indicated, Mr. Chernich offered $4,000 with a mutual release. My attorney came back with a counteroffer. His was a counteroffer. He did not accept Mr. Chernich's agreement, and Mr. Chernich did not subscribe to his counteroffer. So in addition to the terms not being in the agreement, and you asked specifically what terms, those terms were to be that the defendant, University of Michigan Credit Union, were going to release all of their claims against me.
Mhm.
I was going to release all their claims against them.
Yes, and what else?
Defendant Egger was going to release all of her claims against me, and I was going to release my claims against her. None of that is in there in this proposed settlement agreement, and nor is the amount correct, because I did not agree to that.
Well, she's not even in this case. Right? Is she or is she not in this case? Was she ever?
She was in the case.
Well,
Yes, she was.
When did she get out?
She got out of this case. You signed the order to get her out. I believe that was in sometime in April. You signed the order.
Okay, here's my ruling. Counsel, you're going to draft a proposed order under the 7-day. Sir, that means that if he does not follow what I say, then you can file an objection. And then you can propose another order to me. And then we'll have a hearing and I'll decide which one I'm going to sign. But here's the order of the court. It appears very clear to me that there was an agreement. It does appear very clear to me that Ms. Egger was out of this case prior to this June or May agreement. She was out in April.
Mhm.
I only have part of the file, but I remember signing that. That's why I asked when she was out. But nonetheless, I don't know that she needs to be in this. If the university wants to add that she's released, that's fine, but that would really take her to be on notice and be part of this case, and she was out long ago. So I think that signifies, at least to me, that the claims have been resolved, and if he wants to file another claim against her, I suppose he can do that. But this clearly needs to have the $4,000 that will be paid to him within 7 days of the court signing the order. The $4,000 will be paid. There'll be in that order a mutual release of all claims between the two parties that are left in this case, and that is Mr. Robinson and the University of Michigan Credit Union. There'll be no attorney fees, no interest, no nothing. He gets his Volkswagen Jetta, free and clear, which has already happened. That doesn't necessarily need to be in the order. If you want to put it in there, it's already been done, so I think that's moot. And that would close this case. If you want to file another one against your attorney and your former fiance, you're within the 6 years, so you can certainly do that. But I think there was an agreement, it's outlined here, and suddenly you were unhappy with it. So and there's no reason for me to keep this case open, sir. I'm terribly sorry, but I don't. I think this was still an agreement.
May I speak, Your Honor?
You may.
But Your Honor, you can't make an agreement when an agreement was not there.
Looks to me, based on the writing of your attorney, that there was an agreement. And what happened, sir, is in March or sometime during your relationship with your attorney, you said, I want this, that, and the other thing. And he said, okay, I'm going to try to get it for you. And then he did. Now, during the negotiations, and you got the $4,000, it wasn't put in there. You can change your mind. I have nothing in there except before, long months before this agreement goes in writing. They're willing to do that. So there's nothing else really to litigate. I know you say you have more damages, but it's very clear that you went down from whatever it was, the 25,000 that brought you here, down. You wanted more, 212,500. They said no. You said okay, 5. It came at 4. There's some back and forth negotiation. I'm not going to get involved in that. I'm going to enforce a $4,000 settlement. You'll prepare the order, sir.
I will, Your Honor. Thanks.
So
Sir, your next step would be to Court of Appeals, or to file a case against the other two people.
In that order, are you saying then that the claims in the underlying case are released as well?
Wasn't that your understanding?
Yes, my understanding.
So it's all released. You got what you want. He's agreed to it. Is that right, sir?
Yes, Your Honor.
Yes. So all claims are resolved. These are released. You release them, they release you. Now, if you want to go against the other two parties, that's fine.
I'm perplexed.
Well, that's why we have a Court of Appeals. I don't always get it right, sir, but from what I see in the history here, I think that there may be claims against the other two parties who are not parties here, but the credit union has kept up their bargain and they're even willing to put in the other piece that apparently you discussed and wasn't in their discussions, however that happened.
But I didn't agree to the 4,000 amount.
That's between you and your attorney, because what happened was the credit union relied to their detriment on what your attorney said. So that would be an issue for the state bar or another lawsuit, not against this party who relied in good faith. So that's the problem, sir, is you have there's a spider web here. The credit union negotiated in good faith. And I don't know what happened between you and your attorney. That's for another day in court. And I think legally this makes sense. I understand your case law. And if it was just the agreement between you, if you had personally made it with defendant, and it wasn't in there and you agreed only if it was in there with them personally, that would change my mind. But you used counsel, relied on counsel. I don't know what happened there, but you may have a claim against counsel, but you don't have a claim against them. They relied on this agreement that counsel conveyed, and there was sufficient negotiation going back and forth. And although you indicated back in March to your attorney what you would and wouldn't do, this was an agreement that continued to morph until it was finally agreed to, $4,000, and you got your power free and clear. I think it's a right and just settlement against the credit union based on what I know, what everybody's pled in the, not just this file, but there's an underlying file that I have here. And again, you may have a claim against the other two parties, but the credit union's out. You'll prepare an order?
I will, Your Honor. Thank you.
Thank you. Good luck to you, sir.
Thank you, Your Honor.
Gary Alonzo Emmanuel Mann. 26B712364.
Good morning, Your Honor. James King, P number 85229. I appear on behalf of Mr. Mann, who's present via Zoom and consents to being present via Zoom. Mr. Mann, can you state your name, please?
Yes, Derry man.
What in the world is going on with this gentleman?
If
You
I may,
better,
Your
you
Honor.
better, wait, hang on.
Judge, I put a note in there. He received a notice at the window that had a different date on it. That was the confusion last week. That's why I canceled it. And then Mr. King filed an appearance.
Are you gonna be his lawyer, Mr. King, or am I gonna go through a merry-go-round with you two?
I think we're locked in, Your Honor.
I don't know. I mean, I've never seen somebody fire so many lawyers. I'm not putting this off any longer.
I don't
I've had
expect you
3
to.
or 4 different lawyers on this case.
I understand. And with regards to the
I hope
comment,
you do, because I'm telling you, I've had Mr. Upshaw for arraignment only. I had Ms. Tucker Davis. I had, I believe, Ms. Ford, and then Ms. Fanning, and now you. Really? Wow, you're an important guy, Mr. Man. You're a really important guy. I've never seen this. I've only been a lawyer for 42 years, Mr. Man. 42 years, and I don't think I've ever seen one defendant have 5 lawyers before, not once. So I just want to make sure this is the guy you want, Mr. Man. Is this the guy you want?
Yes, sir.
You sure?
Yes, sir.
Because I'm not going to let him get out of the case then. I don't care what happens. We understand one another.
Yes, sir.
It's not you, Mr. King. It's just I'm tired of it. This case has been going on since May the 29th. It's a felony. It's supposed to be out of here in 28 days. Now, we are setting a preliminary exam date, and I'm going to handle that case on that date. It's going to be August the 18th at 11 o'clock in the morning.
Your Honor, I'm actually in a motions hearing in a homicide case on that day in Jackson, Michigan.
Well, let's figure out when we can do it.
In
You
honest-
can do it the 25th, right?
Yes.
August 25th.
Oh,
This
wait,
is
I'm sorry. I'm in the
mine.
wrong month. My apologies, Your Honor. One moment, please.
Your name is this, Mara?
Not something I've never met. And I'm just waiting for the same day so I can sit us on this one.
Yeah, I can do the 25th of August.
Are you in a homicide trial on the 18th, the week of the 18th?
I'm not, I'm out of the, I'm in DC for another case in the week of the 18th.
It's not your fault. I'll go ahead and adjourn exam August 25th. Listen to me, everybody. There will be no adjournments of this. No adjournments of this, okay?
Yes.
Understood.
August 25th at what time, Lisa? August 25th, 11 o'clock in the morning. This exam will be going. Thank you very much, Mr. King. Mr. King, let me
Yes.
apologize. This is not at all directed at you. You got it?
I understand.
All right. I don't want any hard feelings with lawyers. I mean, this is not, you didn't deserve that, but I want him to understand I'm done playing this game. Okay? Thank you very
Understood.
much. We'll see you then. Michael Andrew Felsky, 26W703474.
Will be a launch rate. Good morning, Ron. We have L 580177 on behalf of Mr. Belsky. Sir, please state your name.
Michael Belsky.
All right. The charge is assault, resisting, obstructing officer. Any preliminary matters from the people?
And I did put the defense counsel on notice that the people will be moving to add another additional foul police officer resisting, obstructing, and assaulting, causing injury. That's MCL 750.4793, and that count goes to Officer Lyles.
Right? And that is a 4-year. Okay. Any other preliminary matters? Any objection?
Objection, Your Honor.
All witnesses with the exception of the officer in charge, which is who?
Mr. Mitchell, anyone?
Second disagree.
Oh, this room, never mind. You're the first mouse. Yeah. He's the person.
So you don't have an officer in charge, or you do? All right, then all officers have to leave the courtroom.
Judge, I don't think those are. I don't think they're on our day.
They're not?
They-
Okay. All right, so, well, I'm still ordering all officers, all individuals who are not testifying. Wait a minute, wait, I don't mean you have to leave. Anybody who may testify,
And were you employed with Brookhaven on police department on December 15, 2025? Were you working that day?
I was.
And were you working at 21869 West Road?
I'm sorry, what was?
21869 West Road?
Yes,
Is that in the city of Woodhaven, County of Wayne?
yes.
What's that location?
That is the Woodland Police Department.
And what is it that you were assigned to do that day?
That day I was assigned to regular store patrol duties.
Okay, and what if anything happened that day that brings you forward?
On December 15th, 25, came into our police department. During that, there was a poll, there was a sergeant that came to our station. Once he was in our parking lot, let me talk to him. He had said that he did make the posts.
he said what?
That he did make the posts on TikTok. He consented to a background search. I believe it was on Officer Emery. Shotgun shells were located in his pocket.
Did you serve the shotgun shells?
They're fried shotgun shells.
Okay, and then you stated that there was, what, anything else did you observe?
I then asked him if there was any weapons. He said the shotgun was in the trunk or that of the pickup truck.
Okay, were you able to remember the shotgun?
Yes, I was.
Okay, you stated earlier that there was, a post shell, was that shotgun in the post?
Yes, it was the shotgun that was posted on the TikTok post.
Okay, did you observe the shotgun in the back of the vehicle?
Yes,
And you stated that that was, that was a shotgun that appeared to be the one in post?
yes.
Okay, what did you do with that shotgun?
I then secured the shotgun and
And then was it placed in that list?
yes.
Okay, and then what else did you do after that?
And after that,
I apologize, would you recognize Mr. Busby to get on your knees?
yes, he's currently sitting at the defendant's table, blue shirt on.
What blue shirt is it?
They had a light blue shirt, right? Blue shirt.
And your honor, just sign your record reflect what it says identified Mr. Busby.
The record should so reflect.
Thank you. So at this point, you're in the parking lot with the officers, is the, Mr. Busby, the individual who made the world, she's still alive with that location?
She wasn't present at the time because she did not want him to know that.
Objection, your honor, here's. I'll applaud you.
All right, wait a minute.
It is going for the matter, sir, your honor. If anything, we just goes as to why she left.
Well, I'm gonna sustain the objection. Leave in the words that she wasn't there, and then the rest of it is deleted. In other words, I'm gonna strike the rest of his answer. So if you wanna ask the question a different way, you can.
Thank you, your honor. What, anything else happened, Mr. Busby? Did you recover this firearm?
And after we recovered the firearm, Ben did want to petition to the hospital, so that ambulance coming. We told Ben that he was being taken to the hospital for a mental health evaluation. He then stated that he was not going to the hospital. He then took his hat off and set his hat down. I mean, the engineer was already the car was in my
Was it, Mr. Busby's trying to limit the shotgun sound up?
correct. In my experience, like removing the article, something like that, the symbolic that you are getting ready to fight.
What is your training experience in that sort of stuff?
I'm sorry, what's that?
Okay, so I'm gonna ask you both to keep your voices up. Maybe I'm just getting,
I think it's because the door is speaking to them. It's very distracting.
I don't know what it is, but I just need you both to keep your voices up. Thank you.
You stated that you have experience, with individuals who take their hat off if something is, symbolizes something to you. What is the experience that you've had?
Just the previous experience with violent individuals, people that are fight, they'll remove like rings, or they'll take a coat off, or take a hat off, they'll just remove things, set them down.
Okay, you stated that Mr. Busby removed his hat.
Correct.
And what is it that you were thinking when you did that?
That it was like fight.
Okay, so what did you do after that?
That time I attempted to place him in handcuffs for his safety and for ours. Once I attempted to put him in handcuffs, he then began to fight with us.
Okay, and, at that point, was he being arrested or was it just being, what was it happening?
He was being taken into protective custody, he was taken to the hospital for mental health evaluation.
Okay, you stated that he began fighting with us. Who's us?
Officer Emery and Officer Lee.
Okay, was it, 3 individuals, 3 officers assisting?
At this time, it was just myself, officer, and officer.
How was he fighting you back?
He pulled away. I attempted to grab his arm. He then kind of launched towards Officer Baker. He was not allowing us to put him in handcuffs.
Were you giving commands?
Yes.
Mr. Belsky.
Not exactly sure about watching my video exactly what verbiage that we were giving him. We were going to stop us singing.
How many times did you have to say that? Was it multiple or just once?
We told him multiple times he would not listen to our commands.
Were there other officers giving commands?
I believe all three of us.
Okay. And then what happened after that?
We escorted him down to the ground. He kind of trying to get up, trying to push us off of him. We called for other guards and we were just holding him down until backup officers were able to arrive and assist us.
And then did backup officers arrive?
Yes.
Which officers arrived, if you remember?
There were several officers from the Trenton Police Department and the South Police Department. From the Brownstown Police Department, I know that was Officer Balaki, I do believe, and Officer McNally.
Okay. And then, do you have any other officers arrived, or was it just those 2?
From Brownstown, it was just those 2, I believe. But there were maybe 3 or 4 others from Trenton. And it was Officer Duffy, who now works with the police department. She was with Trenton at the time. She arrived on scene, and there was an Officer Waltz from Trenton. I'm not sure who else from Trenton.
Okay, and then what else, if anything, did you do, with Mr. Belsky?
One of the officers arrived to assist in holding him down. We were able to secure him in handcuffs. But he was still while handcuffed island with officers thinking trying to get back up.
How many officers assisted him, at that point with restraining Mr. Belsky?
There was several. I'm not sure the exact number. Part 3, Officer Falaki and Officer Miles were holding him down. So then at least 5.
Okay, and you stated that what was he doing?
He was while handcuffed. He was still not listening to our commands, trying to get off the way of us, trying to kind of kick out officers.
Okay, were you still giving command at that point?
Yes, we're telling him to stay down and to relax.
Okay. And then were you able to successfully maintain Mr. Belsky or put him in handcuffs?
Yes, he was secured in handcuffs, and we did not calm down. Fire department, she did do evidence medication as well.
Okay, so the fire department arrived as well?
Yes.
And you stated an ambulance was called, did an ambulance arrive as well?
Yeah, it was a fire department property. It's the Woody Fire Department.
Okay, did the ambulance take Mr. Belsky?
Yes, they took him to the hospital.
Okay. And then, do you recall if anything else happened while trying to about Mr. Belsky?
Yes, I don't believe, or I don't recall if he was handcuffed at the time or not. I believe he wasn't handcuffed. Officer Lyles was trying to pull his lights down, and I witnessed him kind of get back. Officer Lyles and I observed Officer Lyles fall backwards onto his arm, on his wrist.
And then, were any other officers, did you observe any other injuries on officers?
Yes, Officer Henry, I saw that get a bloody nose. And I believe Officer Baker had some sort of possibly finger injury. I'm not sure. Do you know for sure that Officer Henry had a bloody nose?
Okay. And then you also stated, well, do you recall how long is the litigation with Mr. Belsky take place? Was it 7 days, was it minutes?
7 minutes.
7 minutes? Okay. And then did you play any other role in this case?
I petitioned him into the hospital.
Did you do anything else after that?
No, I did not. That I didn't know.
Nothing further. Thank you.
Gross.
Yes, thank you, Lauren. Morning, Officer Mitchell.
Morning.
I believe you indicated you were working road patrol that day, is that correct?
Correct.
But you were inside the police station when Ashley Zelsky arrived to make a report,
Correct.
and you'd never met Ashley Zelsky before, correct?
Correct.
And you did not know Michael Zelsky before that day, correct?
Correct.
You had no prior experience with him, correct?
Correct.
And when you took this report from Ashley Zelsky, were you wearing your body camera?
I was. I don't know if it was activated or not because we were inside the station.
But you observed videos,
Yes.
and you didn't think to save those videos at that time?
My first concern was his safety and finding.
Consents to a pat down?
Correct.
So you think he's lucid enough to ask for consent for a pat down, correct?
Correct.
Okay. He's asked about any weapons in his car, correct?
Right.
He provides you with an answer.
Right.
He stands there the whole time.
Correct.
He answers your questions.
Correct.
He denies being suicidal.
I don't recall if he ever denied it. He admitted to making the posts on TikTok.
Okay, and let's talk about those posts. You weren't there when those videos were made, correct?
Correct.
You have no idea when those videos were taken, correct?
Correct. But he was wearing the same clothes.
Sir,
He shot them.
that's not what I asked you. Do you know when those videos were taken?
I did not.
Okay. And you can get a search warrant, correct? You're an officer?
Correct.
Did you do that for these videos?
I did not.
So you weren't with Mr. Felsky, you have no idea when these videos were taken.
Correct.
In this hat situation, you said he sets his hat down on the hood of his car, correct? He continued to talk to you and answer your questions after he set his hat down.
Briefly, that was within 20 seconds of him fighting with us.
Well, let's walk through this. He sets his hat down on the hood of the car, correct?
Correct.
He's standing there. Correct.
Correct.
He's answering your questions, correct?
If there was even any ass, I'm not sure. But
What was seeing you riding on camera refresh your recollection?
it wouldn't.
And for the record, I'm starting at 13 seconds.
No, well, you made some comments that are concerning. So you're just gonna.
Did you get it?
Yeah, you know, coming. Plus, you got any news coming? You can shut it off. I did.
For the record, starting at 29 seconds. Officer, did that refresh your recollection or flash?
Yes. Yes.
Wait a minute, why am I,
It's me, Judge, because I got a lot of letters in now. Or
okay,
if I mute it, maybe that'll help. Did that fix it?
yeah, I didn't hear,
Perfect. So you were asking him questions, correct?
I believe there was 2 questions. Yes.
And he stood there giving you answers, correct?
Argumentatively, yes.
I didn't ask about the types of questions. Did he stand there giving you answers, yes or no?
Yes.
And you went to reach for him first, correct?
Correct.
Okay. So at the time he's standing there, you go to reach for him.
Correct.
And I believe you indicated that you actually filed the petition, correct?
Correct.
And that's because the family declined it.
His mother did not want him to be upset with him.
I didn't ask for the reason why. Is it because the family declined at the hospital?
Correct.
Thank you. And did you follow up to see if Mr. Felsky was released the next morning?
I did not.
Okay, would it surprise you to know that he was?
No.
And I believe you observed interactions between Mr. Felsky and I believe you said Officer Lyles, correct?
Correct.
Did you observe any interactions between Mr. Felsky and Officer, is it Enright?
Yes.
Okay, did you observe Officer Enright dry stun Mr. Felsky?
Drive son.
Dry stun with his taser?
I don't believe he was tased on. I could be incorrect, but to my knowledge, no, you'd have to talk to officer.
Yeah. I have no further questions for this witness.
redirect?
Officer Mitchell, you stated the family declined about Mr. Felsky petition. Why is it that you want to petition him?
For his safety, for his mental health.
Okay, you also stated earlier that he did indicate that he made those posts.
Correct.
Okay, was that when you were just speaking to him?
That when we were speaking in the front parking lot, he did admit to be from social media posts.
Okay, and then you also stated that, how was it? And then you also stated earlier that they were deleted,
Correct.
and when were they deleted?
In between us making contact with him and the mom, prior to speaking with him on the night.
That's not what happened.
Well, he took his keys out, that's admissible.
Correct.
it-
But
the-
providing an explanation. is
I'll strike that for him. You can argue that, Ms. Morrow.
And then, why is it that you reached for Mr. Felsky?
I wanted to secure him in handcuffs for his safety and for our safety. Removing the hat, being argumentative, saying it's not going to the hospital. It's to not want him to be fighting about this.
There was Mr. Felsky free to go.
At that time, he was.
Oh, God. No.
Any other questions, Ms. Belcher?
Officer Mitchell, going back to the interaction with Mr. Felsky and these posts. You asked Mr. Felsky about uploading the TikTok post, correct?
I That's the major posts and you admitted that he did that.
Right, and then he provided explanation, right? He said they had absolutely nothing. It's quite literally TikTok. That's what he said in response, correct?
Right.
And then you asked him more about the suicidal statements, correct?
I believe so,
And
yes.
he says it's quite literally a video. It's a video. Correct?
Correct.
No further questions.
You can step down.
And then, Officer Mitchell, after hearing the explanations, why is it that you still wanted to petition Mr. Cosby?
People lie to us,
Your Honor, that's outside of the scope. I didn't get into why you're petitioning on. I asked about.
No, I think that's fair. Overruled. Answer,
sorry.
answer the question.
People lie to us, if Bond feels that he's a danger to himself, she would know him a lot better than I would. So if he's gonna tell me no, I'm fine, I think this more than no.
Okay.
You can step down. Thank you. Call your next witness. You can come on right up here, officer. Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
I do, Your Honor.
Have a seat, please. You may proceed.
Thank you, Your Honor. And good morning, Officer Lyles.
Good morning.
Officer Lyles, could you tell us where you're employed?
I'm employed with the Brownstown Police Department.
What did you do across town?
I'm a police officer.
How long have you been an officer?
I've been a police officer for about 9 years. But I've worked in the Brownstown Police Department for a little over a year.
Okay, were you employed as an officer on December 15th, 2025?
I was.
Were you working that day?
I was.
Were you in uniform that day?
I was.
What kind of uniform were you in?
I was not at full Class D uniform. When I was there with the work police across my back, a metal badge on my chest, and patches on my shoulders.
And at some point, did your duties take you out of here 21869 West Road?
Yes,
That the city of Woodhaven, County Wayne?
it is.
What was that location?
That's the Woodhaven Police Department.
And what part of that location?
We were dispatched to the Woodhaven Police Department to assist the Woodhaven officers that were actively fighting with a subject. It was originally relayed to us that he may have been armed with a firearm and that they were actively fighting and were unable to take custody and needed our assistance.
Okay, when you stated we, who's we?
Brownstown officers.
I apologize. You said we were dispatched. Were you with
Yeah.
another officer?
No, I'm sorry. The Brownstown officers that were working that day were all dispatched.
Okay. And then were you dispatched with a partner or were you just working alone?
No, I rode solo.
Okay. And when you arrived, could you tell us what you observed?
When I arrived, I observed the 3 Woodhaven officers attempting to take Mr. Telsky into custody. They were sitting on top of him and unable to get his arms out from underneath him. There was another Brownstown officer that was there ahead of me who was also trying to extract Mr. Telsky's arms. When I arrived, I took up the head control position, because that's where there was no.
Would you recognize this individual who saw him today? Could you take a look around the photo right now and please tell us what that individual is wearing right now?
Sitting at the defense table wearing blue polo shirts.
Yeah, I understand maybe they were in the front door. He said that.
Record should so reflect. What other officer from Woodhaven or Brownstown was there?
Officer Black.
So you stated that you spoke to be what we call a head position?
Yeah, head control, correct.
Head control, I apologize. What is it that you were doing?
It's a defensive tactic position that we're trained in. To utilize the head control so that a person can't use their head to resist. When a person's spine is in line, they can have maximum use of their limbs. So when you take their head off of a center position, it can force them to lose strength in their arms and legs so that you can maneuver them.
Okay, do you recall, was Mr. Belsky actively assisting at that time that you were assisting?
He was, yes.
Okay, what is it that you were doing after that?
Continuing to try to position his head in the position to get his arms so the other officers could extract his arms holding his back in accordance with our training.
Were you giving any commands?
Yes, I was advising him to stop resisting.
Okay, were you doing that once or multiple times?
I don't recall.
Do you know what Mr. Belsky when you did not want to stop, resisting or to stop? Was he compliant with your commands?
No.
What is it?
There was multiple officers that were giving him demands.
How many officers of you all were assisting at that time, Mr. Belsky?
I'm not sure exactly how many were there. There were several officers that may have been behind me that I couldn't see.
What, if anything, else happened after that?
So the officers were eventually able to extract Mr. Kelsey from him and place him in handcuffs. During that time frame, we attempted to sit him up under his buttocks. When we were doing that, he began to try to resist. So we put him back down on the ground.
What was it he was trying to resist at that point?
He was trying to stand up and roll. So we decided to throw him back down onto the ground on his stomach. And then he started to kick his legs to try to get away. So we put him into a leg restraint position. When I did that, it took me and 2 other officers to pin his legs in that position. I then sat on those legs to help hold them. And during that time frame, he kicked me off of them.
Okay, and then what happened when we were get going?
When I kicked off of him, I flew backwards, landed on my shoulder, and tried to brace my fall, hurt my fall. In doing that, I hit the ground, broke my fall. I got up, and it was kind of over that. A couple officers asked me if I was okay. I told them originally yes. I believe that it was. It wasn't until afterward that I found out that it wasn't.
Okay, how much time can pass through the fall?
Well, prior to that, I went back over to Mr. Pelsky, because the fire department was trying to administer some medication to him. And he was still actively resisting, so it took several officers to help hold him still, so nobody got stuck with a needle.
Did you continue assisting the officers in the fire department?
Even after being struck by Mr. Pelsky, yes.
Okay, and then what is it that you continue doing?
I took up the head control position again. So he calmed down, and then the other officers transferred him to a gurney. After the incident, I resumed my routine patrol. I took another fall where no physical altercation took place. You just talked to an individual. At that time, my wrist was starting to get very tight and sore. So I went and reported it to the lieutenant, who then took me out of service, had me go to Concentra to be evaluated.
Okay, what happened at Concentra?
When I was at Concentra, they took x-rays and came back and essentially told me that it was sprained.
Your wrist?
Yes, Your Honor.
Thank you.
The right wrist was sprained. And that I should be on light duty until I can be seen about that again.
Okay, and then did you stated the by, but not by Concentra again?
By Concentra again, yes.
By Concentra again,
Yes.
did you go back to Concentra again?
Yeah, about approximately a week-ish, about a week. And we went back and they reevaluated my wrist and they said that I was okay for full duty. I explained to them that it was still sore and tight and I wasn't able to move it. And they told me that may go away over the course of several weeks and to just stretch it.
Okay, were there any scans x-rays or anything done that following the week when you went back?
No.
Okay. And then did you see any other doctors or anything regarding your wrist?
Yeah, so after a period of a couple of months when it wasn't improving, I went to my primary care physician for my annual physical. When doing that, I explained to her the issues I was having with my wrist, the lack of strength, the soreness, the lack of flexibility.
Just to get the timeline, you stated, when is it that you guys get consent preparation?
I went to Concentra on December 15th, the day of the incident.
And then you stated you went back a week later?
Correct. The exact date I don't know.
Okay, and then you said a couple months later you went to your primary care physician?
Yeah, I think it was March 6th.
Okay, around March. Is that when you?
There you go.
Correct, 2026.
Okay. And why is it that you waited about that, like 3 months?
Well, Citra had told me that it was sprained and that it could take some time for it to fully heal. So I was trying to give it an opportunity to heal. Obviously, I would have known that it was more severely injured. I would have gone to another doctor sooner.
Did you go back on duty or were you on light desk work during that time?
No, I was cleared for full duty. So I went back to full duty.
Okay, and at any point within those like, I believe it's about 3 months, did you get into any other altercations or anything that occurred in between that time?
Not that I recall.
Okay. And then, you stated while you were the, your primary care physician, what had happened?
They took additional x-rays, and then called me afterward and advised me that, my scaphoid bone, had been fractured.
Okay. And then what kind of treatment is it that you have to get for that?
So they scheduled me to see a specialist who was a, orthopedic surgeon. In my meeting with him, he explained to me that
Any response?
You're all right.
You what?
I'll move past that.
All right, staying.
What treatment did you get?
I had I had a scaphoid read in, to the bone graft
Okay.
of the right wrist.
And then did you have this, get any sort of physical therapy or anything?
I'm still going to physical therapy, yes.
Okay. When did you start physical therapy?
I had surgery on April 9th, and I was casted until approximately June 26th. And I have been doing physical therapy since.
Okay. And are you back on duty or like that sort of thing?
I'm on like desk work, yes.
Okay. We know, an estimated time until you'll fully recover from this.
They said that I'm feeling well, so hopefully in a few weeks. But everything according to me, it could take up to 6 months or longer.
Then what did you do anything else? Or was there another visit you went to?
I mean, I had a series of visits with my surgeon over this time.
Okay. Do you have to have it? Do you know whether you have any other surgery and that's one?
No, I do need some continuing physical therapy, but no other surgeries at this time.
Okay. Nothing for the business. Thank you.
Cross.
Yes, thank you, Your Honor. Good morning, Officer Wise.
Good morning.
Now, I just want to clear up some things on this timeline. The interaction you had with Mr. Felsky was on December 15th of 2025, correct?
Yes,
And that's a Monday, correct?
I don't know what day it was.
And I believe it was in the evening time when you had an interaction with him, correct?
Yes, it was.
So when you went to Concentra, the medical records I believe show December 16th. Would that be accurate the following day?
No,
What time did you go to Concentra?
I went approximately. Well, it may have been after midnight when they filled the paperwork out. I don't know,
Okay.
but it was that evening.
And that was your first visit?
Yes,
And I believe you indicated they said your wrist was sprained, correct?
that's what they originally did. Yes.
Okay, so the work schedule you were on back then, would you went back to work on the 16th?
No, I was off. I don't recall exactly what the time frame was as far as when I went back to work. Because that was off at one point in time. But I don't remember going back the next day or no.
Okay, well, what was the work schedule like? Full time back then?
I mean, this has been 9 months. I don't recall until when I went back to work directly after the incident. But at the time I worked a 5 and 2 hybrid schedule every 2 weeks.
So explain that to me. I mean,
So I work Monday, Tuesday, Friday, Saturday, Sunday, and then the next week I work Wednesday, Thursday, and the next day Thursday weekends.
okay. And I believe you indicated the next visit you had at Community Center was approximately a week later. Would that have been around December 22nd?
I'm sorry, can you explain the question again?
I believe you said your second visit with Concentra was around a week later. Would that have been around December 22nd?
Approximately, yeah.
Okay. And again, they said your wrist was sprained, correct?
Yes,
And you stayed on regular duties at that time,
correct.
and you continue to work your full schedule
Correct.
up until you got placed on light restrictions.
Correct.
And what was the date you were placed on light restrictions?
I don't recall the exact date. I believe it was March 6th.
And from December to March 6th, do you recall how many different interactions you had with citizens?
I don't have an exact number.
Any resisting, obstructing, or assaultive cases that you were dealing with around those periods of time?
Not that I recall where I was actively attempting to arrest
Okay. What about when you're outside of work? Any activities that would have caused you any injury or aggravated anything to your wrist?
No.
I believe you were on site with Officer Emery, correct?
Correct.
And this is back on December 15th when you were interacting with Mr. Felsky.
Yes.
Did you observe Officer Emery dry stun Mr. Felsky with this taser?
No. Okay.
And I believe Officer Emery had bloody nose, correct?
I don't know what his injuries were. I did observe him having blood on his face.
Well, do you remember laughing with his bloody nose that's at least 6 months off of it?
I don't remember making that comment specifically.
Would hearing it refresh your recollection?
Yes.
Can you pull up your video, please, at Mark 10:14? For the record, what time are you starting the video? And did that refresh your recollection, Officer?
Yes.
Okay, so the bloody nose is at least 6 months off, right?
I can't tell exactly who's saying that in the video. I don't remember saying it, and I can't tell exactly who says it in the video.
Okay. What injury did you have?
A broken wrist.
How much time off is that?
I think according to my doctors, it's at least 6 months.
No further questions.
Read rec.
Just one question, and then officer, is it you stated may have seen the video?
Which state? The 6 months of the favor?
Defendant.
I don't recall, and I can't tell him that. Legitimately cannot tell him the video who says it.
Yeah, you know, that's your voice that says it.
I don't hear it that well from here. I'm not trying to be difficult. I don't know. And I'm not going to testify to something that I can't 100% say.
I understand.
Nothing, sir. You can step down. Call your next
Thank you, Your
witness.
Honor.
No, for the Mr. Rich.
Fine, people need to find over. Anything?
Yes, Your Honor. I was waiting for the officer to step up.
Sure.
Your Honor, what we have here, I'm assuming you want me to start my minutes find over, or were the people making an argument first?
I don't know.
I'll reserve the room.
Go ahead.
Your Honor, what we have here is essentially a wellness check at first. We have a mother who walks into a police station concerned over videos. Officer Mitchell takes the report, doesn't save the videos, has no idea with any prior actions with Mr. Felsky, does not know him, has never met him. He tries to reach out to Mr. Felsky, and what does Mr. Felsky do? He responds back to the police's attempts to contact him. Wants to know why they're contacting him. They ask him to come to the station. What does he do? He complies. He drives to the station. Multiple officers are outside. Mr. Felsky is still outside answering the questions. But what I find interesting is Officer Mitchell indicated that prior to Mr. Felsky even arriving on scene, that he had already called for an ambulance. A decision was already made. This officer made no independent determination if Mr. Felsky was a danger to himself or others. He, under his theory with the mother calling, is going off of somebody else's words or concerns. I could call on my worst enemy and say that I have concerns that this person is suicidal, maybe show something, and get them committed. The officers have an obligation, Your Honor, I think, to make an independent determination. That was not done here. And it can't be both ways. Either Mr. Felsky needs to be committed and petitioned to the hospital, or he's lucid enough to consent to a search, which they took full advantage of. They asked him to consent to a pat down. He said yes. They do the pat down. They find the shotgun shells. They ask him, do you have a shotgun? He says yes. Still compliant, Your Honor. Points him to where it is. You heard Officer Mitchell say he's not free to leave. What crime has been committed? Officer Mitchell says, I grabbed for Mr. Felsky first. I would be upset if I didn't want to be put into a hospital if I wasn't suicidal either. But these officers made no independent determination. Mr. Felsky has a right to resist an unlawful arrest. Just because somebody wants somebody committed, if there's not some other corroborating stuff there that shows his mental health is of concern, Officer Mitchell indicated the family wanted him petitioned. However, we also heard from his testimony, he is the one who had him petitioned, not the family. And as it relates to Officer Wiles, Your Honor, the timing of his injury. He goes to Concentra sometime either around the 15th to 16th, right around. It's a sprained wrist, they do an X-ray. He goes back a week later, sprained wrist, they do an X-ray. It's months later, Your Honor, that we have this injury that involves multiple days off, weeks off, months off, which is, I think, a little alarming when we have officers joking about how much time off we can get from injuries. Your Honor, I think that Mr. Felski has the right to resist an unlawful arrest, and I think that's what he did here.
Thank
And I would argue he's fine.
That was just a brief response. I would say he was not being arrested at that time. He was being petitioned. I believe there was enough to sit here and say that he should be petitioned. The mother comes in, the mother is worried about her son. There are these posts that are being shown to the officer. The officer was unable to download these posts because they were deleted so fast. They were deleted so fast. He stated that there were a previous date and then a date of December 2025, which is the date of this incident, Your Honor, 2025. There were also statements being made apologizing to his mother and that the devil made him do it. So it did draw concerns. Officer Mitchell that this individual might be suicidal, and at that point when somebody might be suicidal, it really is better safe than sorry, taking them to the hospital, making sure that they are getting treatment, care, anything in case they do something. When this person arrives, Mr. Felski arrives, yes, he's compliant at that time, he arrives, but what did they also find? They found shotgun shells and they also found firearm in the back of the vehicle. I also state that the video depicted also does show that Mr. Felski's clothes are similar in appearance, which could show the close time of this post. And the officer did also testify that it was, I believe he stated on TikTok that same date, showing again that this post was made that same date. And was also deleted short time after from the defendant arriving to the police station. And yes, again, he arrives. But even listening to the video, these questions that were being asked, he wasn't even being asked questions. He was told that by the officer that he was going to be taken to the hospital in 911, or the ambulance was going to arrive, and the answers by Mr. Felski were not, okay, that's fine, or even asking questions in any way. He was saying, no, that's not going to happen. No, that's not going to happen. And what did he do after? He reaches for his car keys, which he kept indicative that this individual is about to run to his car and try to get away. And again, this officer doesn't know that there's something going on mentally. He also did admit that these posts were made by him, Your Honor. So again, it's better safe just been sorry that he to petition somebody, especially when their family themselves, somebody who knows them better, is the one who deliberately came to the police department to make this report, even if they did later on change their minds. And again, we don't know what that reason could have been for, but there could be a good reason for that. The officer saw fit that this individual should still be petitioned based on all the things that were seen in the videos, found in the shells found, the gun found.
I heard him now. Thank you.
Yeah.
He corroborated this. I mean, we've still got an officer that saw the post. He was alerted. There's a firearm in the post. Sorry, devil made me do it to his mother. He corroborates when he has a discussion with the defendant that the defendant, well, first this prosecutor pointed out he found the shotgun shells, and then he also got him to surrender the firearm. So when you take in the totality of the circumstances and the fact that the post happened that day, granted it was deleted, and the clothes that the defendant was wearing were the same or similar to the clothes that he came to the police station, I find that the arrest was in fact lawful. I'm to bind the defendant over for trial. It's a good argument. Did a nice job, Ms. Belcher, as I always expect you to. But I'm convinced that that the officer had the right to effectuate arrest, not for the purpose of arresting him because of unlawful activity, but because he believed he was a danger to himself and or others. So I'm going to go ahead and bind the defendant over. I'll include on there the assault, resistant, obstruct, causing injury. The prosecutor indicated she was going to ask a bind over on pursuant to MCL 750.479 parent 3, which is a 4-year felony. And the AOI date in this case will be 2 weeks from today, which will be on August the 18th. The defendant's bond is continued of $10,000 personal. Same terms and conditions, sir. Okay? Thank you both. Have a great day. Do we have any more that we're going to do? You did do a nice job, Ms. Belcher. Thank you. I mean it. I never thought I'd say that to you. I'm just kidding. No, really, I really was impressed this time.
I have not.
But not that not that you have not impressed me in the past.
We are on the record now in GW 2026 CR 42, State of Kansas versus Seth Michael Daniels. This does come on for preliminary hearing. Please announce appearances.
May it please the court, the state appears by Jill Gillette, County Attorney.
Mr. De Hoyos is muted.
Sorry about that, Judge. Jorge De Hoyos here on behalf of Mr. Daniels, both representing the defense, appearing by Zoom.
And your client does wish to proceed with preliminary hearing, Mr. De Hoyos?
At this time, Judge, yes.
Ms. Gillette, are you ready to proceed?
We are, Your Honor.
Please call your first witness.
Your Honor, we will be calling Sergeant Cordell.
Okay. Sergeant Cordell, please raise your right hand. You solemnly swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Please proceed.
Could you please state your name for the record?
I'm Mike Cordell.
How are you employed?
I'm a patrol supervisor and canine handler for the Greenwood County Sheriff's Office.
How long have you been so employed?
I've been with the Greenwood County Sheriff's Office for just under 10 years, and I've been full-time law enforcement certified for just over 22 years.
And were you on duty on March 7th of 2026?
Yes.
What drew your attention to the defendant?
So first time I saw Mr. Daniels' vehicle, I was on patrol in the parking lot of gas station on 400 called Pete's. Noticed a red Dodge Dakota at the pumps, ran the tag, which late at night I often do with vehicles. I found that vehicle to be registered to Mr. Daniels, and upon further investigating Mr. Daniels' driver's license, I found that he was a registered drug offender and the vehicle was not associated with his offender registration.
And do you see the defendant on the screen with us today?
Yes, it'd be the individual whose screen says Seth Daniels, white shirt and a beard.
Your Honor, may the record reflect he's identified the defendant.
The record shall so reflect.
And Sergeant, when you found that the vehicle wasn't on his offender registration, did you also, when you were running the license plate, did you notice anything about it?
Aside from the fact that there was no license plate light, I don't recall anything that stands out to me.
Okay. And did you conduct a stop on the vehicle?
I did not. So I watched the vehicle as it left the parking lot. It failed to stop entering the roadway, and I contacted Deputy Taylor Cordell and requested that she stop the vehicle once it got onto the highway.
Okay. And did Deputy Cordell then stop the vehicle?
Yes.
And where did the traffic stop end up taking place?
I believe it was 400 Highway and V Road.
Okay. Is that within the bounds of Greenwood County?
Yes.
And as Deputy Cordell was conducting the traffic stop, what did you do next?
I deployed my canine partner, Kraken, and conducted a free air sniff around the exterior of the vehicle.
And after you had deployed Canine Kraken, did you notice any alert on the vehicle?
Yes, so he actually showed alert behavior in two locations, one at the passenger rear side of the vehicle, and then once again on the driver's side.
Okay. And did he give a final indication?
I don't recall. I believe he did at the driver's side, but I don't want to say for a fact. I noted in my canine deployment log that there was an alert at the passenger side rear and the driver's side. I did not notate that he gave a final indication, but he may have.
Okay. And do the canines detect the odor of or presence of a drug?
They detect the odor of a drug for which they're trained.
What drugs is canine Kraken trained on?
Methamphetamine, heroin, cocaine, and fentanyl.
And when canine Kraken alerted on this vehicle, did you inform Deputy Cordell?
Yes.
What did you guys do next?
She had the occupant step out of the vehicle, at which time I conducted a search of the vehicle.
And based on the probable cause search, did you find anything of evidentiary value?
Yes. So in the glasses holder on the center of the roof of the vehicle toward the windshield, there was a bag containing 2 large crystals of what I identified as methamphetamine.
And is there anything else besides the methamphetamine that you seized out of the vehicle?
Yes, there was some other assorted paraphernalia. There was a syringe. There was another bag that looks like a $20 bill that was located inside a purse in the vehicle as well.
Okay. Did that plastic bag contain residue?
Yes.
And did you find any pipes anywhere?
I believe there was a pipe that was also located in the vehicle. I'd have to refer to my report. I don't recall where that was located.
Did you bring your report with you?
I do have it, yes.
And did you write your report at a time close in time to the stop?
Yes.
Did you do so to refresh your independent recollection?
Yes.
Would it assist you to refresh your recollection at this time?
Indeed.
Your Honor, may the officer refer to his report?
The officer may refer to his report to refresh his recollection.
I believe there was a pipe located inside the vehicle, but the reason that I don't recall where it was located was I believe that was located actually by another deputy, that Aiden Miller, who was riding with me at the time.
Judge, if the deputy does not have this memory themselves, then I'm going to move to object to hearsay on all of it.
Well, I don't think he said anything that was an out-of-court statement yet, so I'm going to let him finish his sentence. He said he thought it was found, and that's different than saying what Deputy Metland said. So let's let him go. Let him go a little bit further.
We'll switch. Did Deputy Cordell receive an item from Ms. Hill from a private part?
Yes. So once both subjects were transported to the jail, she recovered from her person a methamphetamine pipe, which she had been hiding in her vagina.
And the rest of the drugs, were they within reach of the driver, Mr. Daniels, who was in control of the vehicle?
Yes. And then also I completed a supplement after the initial report that I had written, when I located a syringe in the prisoner transport cage of my vehicle, which was not there prior to transporting Mr. Daniels and was there afterward, and nobody else had been in the transport cage. I did not recover that from his person at the time, but it was located in the transport cage immediately after transporting him. There was also a syringe in his right front pocket when I arrested him that I did locate.
And did you send the items to some of the items to the KBI lab for testing?
Yes.
I believe Missy has those results, Your Honor.
Very well. Missy, do you want to, are you moving to admit those?
Hold up. Let's back this up just a little bit.
Okay.
And did you send the items to some of the items?
I did not recover that from his person at the time, but it was located in the transport cage immediately after transporting him. There was also a syringe in his right front pocket when I arrested him that I did locate.
And did you send the items to the some of the items to the KBI lab for testing?
Yes.
I believe Missy has those results, Your Honor.
Did I not go far enough back?
Very well.
Right.
Not a court statement yet, so I'm gonna let him finish his sentence. He said he thought it was found, and that's different than saying what Deputy Metland said, so
Well,
let's let him go. Let him go a little bit further.
We'll switch. Did Deputy receive an item from Ms. Hill from a private part?
Yes. So once both subjects were transported to the jail, she recovered from her person a methamphetamine pipe, which she had been hiding in her vagina.
And
that's what I thought I heard.
Rest of the
That's
drugs,
it.
were they within reach of
I
the
heard it.
driver, Mr. Daniels, who was in control of the vehicle?
Yes. And then also I completed a supplement after the initial report that I had written when I located a syringe in the prisoner transport cage of my vehicle, which was not there prior to transporting Mr. Daniels and was there afterward, and nobody else had been in the transport cage. I did not recover that from his person at the time, but it was located in the transport cage immediately after transporting him. There was also a syringe in his right front pocket when I arrested him that I did locate.
And did you send the items to some of the items to the KBI lab for testing?
Yes.
I believe Missy has those results, Your Honor.
Very well, Missy, do you want to, are you moving to admit those?
We will be moving to admit the KBI lab as state's exhibit.
Okay. Hearing no objection, Exhibit 1 will be admitted. Missy, if you'll publish that by screen share.
And Judge, I think if you click on that and blow it up, you can see that the bags containing the crystalline substance, one was tested and that it weighed 2.53 grams and was positive for methamphetamine. And I believe the pipe was for Ms. Hill, and then the vegetation is a misdemeanor.
Okay, so the meth in item 2, the pipe with residue, you're connecting to this defendant or with
No,
the
that's Ms. Hill's pipe.
Okay.
The
So
bag
it's-
containing crystalline substance that was in the glass of the car that
2.53 grams you're attributing to this defendant. Okay.
yes.
All right, you may proceed.
And
Seth looks
Deputy,
confused.
did you Mirandize these defendants?
Yes.
And did Mr. Daniels make any statements to you that were of note?
Yes, he said that he had been stopped by Rose Hill Police Department and that they had found methamphetamine in that same location, and he claimed that it was the same methamphetamine and the Rose Hill Police Department must have put it back in his truck.
So the cops put it there. Interesting play. And the strawberries?
I will pass this witness to the defense.
Mr. DeHoy, this cross-examination.
Sergeant, you said that you first came across the vehicle at Pete's gas station there on 50, or is that 400?
Yes.
Okay. And have you worked with Pete's gas station before?
I guess I don't understand what you mean work with.
I mean, have you ever collected evidence from Pete's before?
I think on cases like burglary case in the past, we might have pulled some video from there.
Okay, so you're aware Pete's does have cameras over their parking lots, over their area. Is that right?
Actually, their cameras covering their parking lots and their pump area are pretty minimal, but there are some cameras there. I just don't know what they cover.
And have you collected the footage from this night?
No.
Okay. So to be clear, in evidence, what we have is your word that they failed the traffic stop and your word that the tag light was out.
Correct.
Okay. So if the video by Taylor Cordell demonstrates that the tag light was working properly, you would agree that that's inconsistent with your personal observations that are not supported by any other evidence and record?
No, I wouldn't agree. It's inconsistent. There are times where lights go on and off. I don't believe the tag light was working when she stopped him, but even if so, I wouldn't say it's inconsistent with my observations. Sometimes going over bumps, the lights will flicker on and off. So that's a possibility if it was working later. He also failed to stop exiting the private drive, which I observed personally.
And you could have brought us the camera footage or gone collect camera footage of which you haven't.
They don't have camera footage of the entrance or exit of the parking lot. I can guarantee that. I know that they don't cover that area.
Okay. And it's just a coincidence if his tag lights were working and you said they weren't.
If it was working when it was stopped, then yes, it's a coincidence because it was not working when I observed it.
You said that the passenger in the vehicle had a methamphetamine pipe in her vagina.
Yes.
Okay.
And again, it was said.
Did you associate her with the methamphetamine found in the vehicle that would fill that pipe?
I believe she was also charged with the methamphetamine, yes.
Okay. Did you fingerprint the baggies or anything that the methamphetamine was found in?
No.
Why is this his meth and not hers?
Well, it's his truck registered to him, and it was in the glasses holder in the center of the vehicle, which was within reach of him. And he also claimed that it was the same meth that was found in his truck previously when Rose Hill Police Department stopped him, and that they put it back in his truck.
And then you said the K9 unit now is Kraken. It's no longer Kilo.
Correct.
Okay. It's irrelevant. Where's Kilo at? Did you manage to adopt Kilo?
Yes, he's living here at my house with me.
That's awesome. I'm happy for you, Sergeant. No further questions.
Yeah, good dog.
Yay, Kilo.
Ms. Gillette, back to you.
Sergeant, just a couple of follow-ups. First off, this defendant also had a methamphetamine pipe or syringe in his pocket.
Correct. He had a syringe in his pocket and then one that was abandoned in my prisoner cage in my vehicle after he was transported.
I'm going to object to the classifications on methamphetamine syringes. That has not been fully established.
And do you still have the syringe in evidence?
It would be in evidence, I believe, yes.
And
for the record, I'm overruling the objection.
And do you believe the syringe tied the defendant's methamphetamine use?
I do.
And did he admit to you that he knew it was there? I presumed that Rose Hill had put it back.
That's correct. He said that Rose Hill Police Department must have put the meth back in his vehicle because it appeared to be the same meth that they had taken from his vehicle.
That makes sense.
So he had knowledge that there was meth in the glasses case previously.
Yes.
Okay.
It makes complete sense, doesn't it?
No further questions.
Any recross, Mr. DeHoyas?
Sergeant Cordell, if somebody is unaware there's something in their vehicle, is it inappropriate for them to speculate as to how it's there or why it's there?
I'm sorry, if they're unaware it's in their vehicle, and then I didn't understand the rest of your question.
If somebody was unaware, is it inappropriate for them to tell you how they thought it may be there or speculate how it came to be?
I suppose one could speculate, but everybody claims to be unaware of the drugs I find in their vehicle.
Sure, I'm not talking about everybody, but in this case, he never claimed ownership of those drugs. He said that he believes that may be the drugs that were left over by Rose Hill.
Yes, his explanation was that he believed Rose Hill Police Department had charged him with methamphetamine and then put the evidence back in his vehicle. That is what he stated.
Okay.
Whether he believed that or not, I wouldn't go as far as to say he believed that, but that is what he stated.
Why would you not go as far as saying that he believed that? I'm confused.
Because it's illogical to think that the police department charged you with drugs and then put the drugs back in your vehicle. So I believe that was a statement he made to try to explain it, albeit a ridiculous statement. Also, after contacting Rose Hill Police Department the following day and verifying that they do have the drugs that they seized from him in the exact same location in his truck in evidence at the time of his arrest on my case, I just don't see any way that he would believe that. As a registered drug offender, he has obviously a significant enough history to be registered. I think that he'll probably say whatever in order to not be charged with the drugs in his vehicle. So no, I didn't believe that he actually believed they put the drugs back in his vehicle.
That's how you tell him.
I'm not going to object for the purposes of the prelim to that answer, Judge, but I think you can understand why I would at the trial. That being said, I have no further questions from Mr. Cordell, or Sergeant Cordell, forgive me.
Well, I think the concern I would have is that you're asking him to speculate, and he can't do that as to what's in this man's mind. But
that's right.
But nobody objected to it, so all right, noted. Is that all of your questions, Mr. De Hoyos?
For Sergeant Cordell, it is.
Okay, Ms. Gillette, do you have any other evidence?
No, I think Deputy Cordell primarily has to do with the pipe in the vaginal area. So no, I believe we'll rest at this time.
All right. Any evidence from you, Mr. De Hoyos?
Not for the purposes of today, Judge. I appreciate the opportunity.
Thank you. I do find probable cause to believe the crime in count 1, the felony possession of methamphetamine and/or MDMA, has been shown, and there is probable cause to believe this defendant is in violation of count 1. So I will bind the defendant over for arraignment. And Missy, when will this be conducted?
This case will go to Judge Ricky.
Ricky?
And he's available September 10th.
September 10th?
I have 10 o'clock, or I have time in the afternoon.
Counsel?
I don't like Thursdays much, but I could do the afternoon on the 10th.
What time? 1, 2, 3, or 4?
Just a second. That's by Zoom, right?
Yes.
1 o'clock is fine.
All right, so I understand that is 1 o'clock, September 10th with Judge Ricky.
Yes.
Judge Ricky's going to love this one.
All right. Mr. Daniels, you are bound over for arraignment before Chief Judge David Ricky. You must appear by Zoom September 10th at 1 p.m. The codes will be different. So if you don't have those within a day or two of the hearing, you might check with your attorney, see if he has them. That's where they usually go, and/or to the clerk of the district court. You are continued on your bond until that time, sir, with all existing conditions and the added conditions that I've just imposed upon you to reappear. Anything further from anyone?
Not by defense.
Very well. This hearing is adjourned. Thank you.
Thank you.
Well, that's how the cookie crumbles. Got that, I think I had to make 3 different reminders tonight. One for Judge Ricky, one for Judge McNally. Maybe it was just 2. Maybe it was. Doesn't even matter. Thank you all for hanging out with me tonight. It's been amazing. I can't believe that we had to hear all about. I'll be honest. I thought it was I thought the last case was mostly interesting because I heard about cracking the canine, and I thought that was super funny. And it's the main reason I included it. And then we find out the passenger in the car had a pipe in one of the most unexpected places. Very uncomfortable place, it sounds like. Oh my dear God. And then to find out that the officer who was testifying was mostly involved with the discovery of that particular item in that particular spot. I have so many more questions. We need to figure out what her name is and figure out when she's up next. Oh God, that would be an interesting evidentiary hearing to watch if we could find it. I have a lot of people to thank tonight. You've all been amazing. I can't say enough. All the gifts, all the bips and bops. Most especially, I got to say thank you to Darth Steven, the objectioner, Miss Natasha Kitty, unbiased jurist, Dan and Joan. Thank you all so much. The puppies, the puppies are getting better. Hopefully, I'm going to get a little bit more sane. Sky Hidden, thank you so much. Tracy, thank you so much. Darth Steven. You are the giver, the giver, the giver. Thank you so much. Inspect wherever you are out there. We miss you. We hope you're okay. Rhonda, we've been looking for you too. I know you probably passed out. I don't blame you. I'm surprised I'm even awake right now, to be honest. As little sleep as I've gotten from puppy problem. We're gonna get these puppies well. They're laying down right here. You can't see them from your angle, but they're right there. We're gonna get them well. We'll all be happy and healthy as much as humanly possible and doggily possible. I don't even want to say it anymore. Guys, it's been an amazing show. I had a lot of fun. Judge Aquilina had an interesting case there. I thought it was interesting. I can't believe that guy just $4,000, all that nonsense, emotional damage. I don't even know what to say about that. And Mr. Man, I hope Mr. Man gets it together. Mr. Man needs to get it together. We'll be looking for that story later. What can I say, ladies and gentlemen? Thank you so much, Soldier, Eileen, Becky, Kieran. I am your lone wolf Usla. I'm the guy who puts all this crap together. I'm beat, and I am out. Nothing special coming. And remember, only you can take a bite out of crime. Bye! I told you I didn't know what I was doing. But you got one last bong for the night. Ha! How you like that? Take that Ferris Bueller reference and bong it. See you, OSG. Yeah, I want to know who found the pipe, too. Yeah. Bye! And remember, only you can take a bite out of crime. Bye!